Hello, Corey. We are live. Um, we live in an unprecedented age in terms of the American presidency. You're a constitutional law scholar, so you study this stuff. I I'm presuming that in terms of what you do, you're happy to be alive right now. The
Yeah.
amount of norms, stress testing that the American Constitution and the office of the presidency is actually going through right now.
Well, I often thought, may you live in interesting times. And, Obama had some constitutional dilemmas that came up, some that we should have talked about, but he was a pretty great president. He was a constitutional law professor. And I was happy to play golf. I didn't feel like there were a lot of constitutional emergencies or hang out with friends. And these days, I'm busier, certainly. I don't know if I'm enjoying it. I mean, I think it's frankly, very frightening that this is, sort of hypotheticals that we talk about in classrooms about the danger to democracy coming to life in the form of this actual person. And, he's failed often, thankfully. He's been stopped sometimes by courts, more often by his own incompetence. But that doesn't, I think, hide the danger and the danger in particular of his aspirations. So I wouldn't say I'm enjoying it. I'm mostly worried.
Okay, so explain to us, give us one instance where President Donald Trump, from a historical point of view, let's try and keep party politics out of it as much as we
Sure,
can. From a
sure.
historical point of view, what is he doing which is breaking norms?
I think the most important and drastic recent example was the consideration and initial use of the military domestically. There's a long tradition of not allowing the president to use the military domestically, and there's a famous law called Posse Comitatus that talks about the limit of the military on U.S. soil. But as often happened with this presidency, there are ways around it. And this president almost instinctually goes for the most aggressive stance initially, and then we have to engage in this constitutional dilemma about whether or not he can be stopped. So when he used the National Guard to stop this protest in front of the church to secure his photo op, that certainly looked like, well, can he do that? And that was in Washington, D.C., so that's one exception. Another thought is that more generally, he has a law called the National, um, that he has legislation called the Insurrection Act that allows him to call up the military even over the objections of state governors if he believes that the states are unable or unwilling to protect fundamental rights. Now, uh, I can tell you that he thought, and he had attorneys telling him, that he could use that law to overcome even objections by state governors and to say, send the military to New York to stop protests. I have been saying on radio, and I'm writing something about why that's a misunderstanding of the law and why it's a misunderstanding of the role of the president. But it was really up to military officials to push back and through the political process. We didn't, thankfully, have to see that come to the courts yet. But the fact that he was even considering it is to me a shock to the system, and that he did this initial terrible thing, which was to use the National Guard and the military police in order to clear away basically space for a photo op to stop free speech, right to protest in order to do it.
So, okay, I have a little bit of an understanding of presidential history, not as
Mm.
much as you. And what I don't have is your understanding of the American Constitution, the Declaration of Independence, etc. Um, but what is the Why could General Washington
Yep.
don his uniform and try and put down Shays' rebellion? Isn't that sending the US military into a domestic disturbance? What's the difference between Shays' rebellion and Donald Trump wanting to have a photo op outside of a church and needing to find his way there?
I mean, I think the main difference is that over time, this is very early on in the history, Shays Rebellion that you're talking about. It was a true emergency threat, and there probably wasn't the local ability to suppress it. I have to look into the details there. A lot of it would depend. Certainly, I think there's no question that a state can invite the military in. The constitutional question is over the objections of the state. So I have to look at whether or not local officials were objecting to the use of the military in Che's rebellion. I just don't know that offhand, but it's an interesting question. The other very famous historical example, of course, is the Eisenhower example, where former General Eisenhower did use the military, including the same unit that stormed the beaches at Normandy, to essentially go into Arkansas over the objection of the governor, who was, of course, blocking the entry of these Little Rock students into their school that they were entitled to go to as a result of a district court order. Now, that was in opposition to a local official. So, one real question that people have been raising is this like that? And my answer to that, it's not going to surprise you, is no. That was an instance of the president of the United States using the military to take on a governor who was was refusing to enforce civil rights and was doing the opposite. And that's the way the act is written, is to allow the military to be used in order to enforce civil rights over the objection of a governor. What was the civil right that the president was trying to take care of, to protect over the objection of a governor? If he was going to use the military to basically suppress police forces that were beating people up, I'd say actually that looks a little bit like the Eisenhower instance, but that's not what he was doing. He was doing it, for general questions of stability that I think are not really handled by the act. And there is a language in the act about basically the failure of a state's ability to take care of local insurrection, and that's just not what's happening now. It's protests. It's there is some violence, but I don't think it's out of the control of the governors to deal with it. So I just don't think that the analogy to Eisenhower works at all.
So specifically, I think the American military have been uncomfortable. We've had various ex-chiefs of staff just say this is wrong. Constitutional law scholars, people like yourself, have said this is wrong. What is the immediate comeback on a president that let's say breaks that norm?
I should say, I think in constitutional law scholarship, as in the military, people are divided. I've felt a kind of sense of urgency before. I guess, I don't mind sharing this. I had a piece under consideration from the Washington Post that turned out not to get in. What got in the same day was a military official is making a similar argument that the military isn't good at protecting free speech. But I felt the need to write it, especially before that piece came out, because so many law professors were just reading the act in the most literal kind of way, without attention to the kind of civil rights that are really at stake in the act and that are behind it. And what they were really saying is, and this is the comeback too of the administration, it's up to the president, that this gives a lot of power to the president, this Insurrection Act, to decide when states are unable to do their jobs and to send the military in. And it really is a sort of grant of almost an authoritarian power to the president. So I don't want to pretend that, there isn't a comeback or that this is an easy question. It really isn't. And I've spent a lot of time reading the statute. It was pulled back at one point. There was much broader language that was pulled back. So that's part of the debate, I think. The other thing I've got on my side is during the Bush administration in his second term, there was a memo written about an earlier memo, all about the Insurrection Act. The first memo written by John Yoo, who defended, of course, the president's torture as legal, said the president can use the Insurrection Act at will, basically, and civil liberties have to be subservient to questions of insurrection at the president's judgment. And the second memo from the Office of Legal Counsel said, disregard the first. That's very dangerous, what John Yoo was saying to us. And even though we're in the same administration as him, we've got to really care about civil rights and the right to protest and the right to free speech. So, the Constitution is a very fragile thing. It's easy to collapse it. And that's why I'm trying to do my best to speak out against it. And you made a great point in the beginning, which is we don't want to be partisan when we're talking about this. And kudos to George Bush in his second term in his Office of Legal Counsel for really providing us the best argument against Trump's ability to use the military domestically.
Sounds to me, being a Brit, that your president almost has the power of a monarch. And surely the whole point of if he can call in the military whenever he wants, wherever he wants or she wants, That is surely one of the founding things that you guys fought against. Is this a symptom of the imperial presidency, that what was initially envisaged, the scope and the role of the presidency has got bigger in the preceding 200 and plus years, and maybe if the position is open to so much interpretation, that maybe there needs to be another amendment to the Constitution which clearly defines and checks and locks the power of the presidency, because otherwise he's wearing a crown, and for what it's worth, our British Queen could not pull out the military to go anywhere within the United Kingdom.
Yeah, I mean, you're identifying the central dilemma. The first thing to say is that the Insurrection Act can be clarified through ordinary legislation. We don't need an amendment to the Constitution. We can just have a majority of Congress. The president, of course, has to sign on to it to limit the ability of the president to do this. And I think that's something that certainly should be done, because the fact that there's any ambiguity here does open the possibility of imperial presidency and that kind of way of acting. In a broader frame, Schlesinger, of course, coined that term, used it in his book, The Imperial Presidency. And his story is really, we had a great limited presidency, and then, early in the Republic and then late in the Republic, Johnson and Nixon create this imperial presidency. And in my new book that I'm writing, I tell a somewhat different story, which is that we've really had kind of constant struggles between presidents who have acted in an imperialistic kind of way, and then periods of time of recovering from them. And there's no better example, for instance, than the Adams presidency, which was a kind of imperialistic presidency, I think. So we've got those two strands. And yes, the key is to, exactly as you say, to restrain the president so he can't act like a monarch, or she.
Okay, so specifically, that's one instance where he called in the military to be on the streets of Washington during the President George Floyd protest, the Black Lives Matter protests. But you have at least another two ways where Donald Trump has broken with presidential norms. So why don't we jump into the second one?
I was just going to say on this one, on the same, broad question, in addition to the calling into the military in the case to clear the church, another example to me that really was frightening was, I listened in depth, and anybody can listen to it on the Daily, for instance, excerpts to now public phone call between the president and governors. And he's threatening them. I am going to do this. And he's using, I think, that photo op to just show that he means it, that he's going to go in and use the military in this way. I'd say a second, though, if we're going to switch topics and go to a different issue. The president has a personal attorney who's making an argument on his behalf in a case in New York in which the local district attorney, Cyrus Vance, is trying to get Donald Trump's taxes. And the argument in response to that has been, a sitting president not only can't be subject to criminal indictment, something that I'm happy to talk about, but can't actually also even be criminally investigated. And in the Second Circuit, that lawyer was asked the following question: what if Donald Trump really did kill somebody on Fifth Avenue? Could he not only be indicted, but couldn't be investigated? And the lawyer said yes. Now, that case is before the Supreme Court. It's this generation's U.S. v. Nixon. Of course, in U.S. v. Nixon, for those who listen to our impeachment podcast, was a case in which the president was subpoenaed for information in an ongoing criminal trial. And the court basically said, yes, the president has some privileges, but the president isn't above the law. And 8-0 made the president turn over the Watergate tapes that led to the end, eventually, of the Nixon presidency. Now we're revisiting it. To me, that clearly says, yeah, a president can be investigated. But am I fading out there?
Yeah, you did. You faded
okay,
out, but you're back.
That's Trump coming to get us. The Nixon case, was 8-0. But I don't think this case is going to turn out necessarily to be 8-0. There's Justice Kavanaugh, for instance, who's been very pro executive power, pro in your terms, imperial presidency. And you know, I worry. I think the oral argument went pretty bad for Trump. I listened to it in depth. But it is possible that they can do a variety of things, including send the case back for more consideration and delay. And as the Manhattan District Attorney said, in this case, look, there's a 5-year statute of limitations. And if the Trump people succeed, in, even if they don't win, if they can delay 5 years, they're going to win just because the time's expired. So that's also, I think, another example of what you're talking about, a kind of imperialistic threat to the rule of law.
Okay, so I find this utterly fascinating that you Americans are so you revere the Constitution and understand from a historical point of view the American Constitution is groundbreaking in that it's the first constitution of any nation state. You know, up until that point, uh, England just evolved, Denmark just evolved, the Zulu kingdom just evolved. It just was. There were certain norms as to how that polity is governed, but it was never written down. And that's what happens when the rebellious British colonists decide they don't want to be British colonists anymore. They want to be Americans. Got it. But it's fascinating for me, considering how much you revere the Constitution, and it has these various amendments, 26 or 27, I can never remember now. And it's seen as a document that holds ultimate truth, pointers to behavior that the various levers of American governance should govern America by. But it's open to so much interpretation. Is that the strength of the Constitution historically, or is that the weakness?
Yeah, I was thinking that the whole time. That I was gonna say exactly. You've identified the strength, and you know, go back in time. So you know, I'm previewing a little bit this book that I'm working on now. The hero to me of the book is, well, is not to me. You'll see it in the book. Is the constitutional theory of Frederick Douglass. He's the constitutional hero, and part of what I'm saying is that the brilliance of the document is that because it's so much about values. And it is written in these broad and vague ways that allows dissenters, people who have been left out, to claim their rights. So as much as the presidency matters to our republic and to the protection of the Constitution, in fact, the presidency matters much more than courts, which have historically undermined the Constitution, worked with presidents when they've been undermining the Constitution, failed to protect the Constitution from presidents. So it really is largely about the person in office. But I'd say the second thing that matters most is not courts. It's what I call constitutional constituencies and constitutional constituents, citizens who are able to say, to look to those principles and say, hey, I'm going to claim this for myself. And there's no better example of that than Frederick Douglass in his life, but also in his constitutional theory, which was all about what I'm saying. And he says, you know, look, if you look at the principles early in the Republic, there is, for instance, a ban on children inheriting the punishments and crimes of their parents. There can't be in the Constitution's word corruption of blood. And he uses that to say, you know, that looks like it's a kind of narrow, weird thing, but no, it's about a principle of equality. And that's the principle that was identified by Jefferson in the Declaration, and that's been so terribly betrayed by the actual people in power since the founding of this country. So Douglass, in a sort of brilliant move of constitutional interpretation, is doing exactly what we've said. And Jefferson himself, to go back to him, was an opponent of the idea that courts should have the exclusive monopoly on interpreting the Constitution. He said, look, if you leave it to courts, and you see the document as sort of technical, it'll be like a thing of wax that can be molded into whatever the people in power, 5 justices, you know, well, at the time it wasn't 5, but a majority of justices want it to be. And that's not what it is. It's an independent set of moral ideals. You know, he had influenced it, of course. He wasn't there for the writing of it, but he certainly wrote the Declaration. And his point was, you know, my friend Madison and I, who basically wrote much of it, we know as much as the courts when it comes to what it means, and we can claim it. And then Douglass is doing that one better and saying the right thing, which is no, citizens actually probably do it the best. And it's citizens, I think, arguing and telling presidents how to act that gives us our best moments in history.
We just have a message here from Luke Baxter. It says, "Sorry, I missed the start. What's the overall theme of this discussion?" I believe we're talking about the ways, Luke, in which the current president of the United States has at least tested existing norms of what the president should actually do. And we're trying to be as non-partisan as possible and trying to look at historical precedent for this. Cory, interestingly, you mentioned the Constitution being used by people which it has left out. Maybe you could inform us of to the recent Supreme Court justice ruling and how that has taken, let's say, a 1960s view of discrimination and updated that for 2020, because I think that goes to really answer your point there.
Yeah, I mean, one of the great moments of what I'm talking about, certainly in history, and it's a brief moment, is Martin Luther King and Lyndon Johnson, of course, working together to pass the 1964 Civil Rights Act. Now, that's not a constitutional act, it's an act of Congress, but it's the realization clearly of an ideal that was set out during the Reconstruction period and never really guaranteed. There's a lot of interesting constitutional law about the 1964 Act. It was upheld under the Commerce Clause rather than the 14th Amendment Equal Protection Clause. But to my mind, it's really about the ideal of equal protection. But it also does something that courts at that point had not done, which is guarantee the rights of women. And that brings us to the current case. That act included a ban on discrimination, firing really, and employment based on sex. That's the language that's used. It was at the time largely thought to be about gender equality. And there's a weird history of how it got passed, where it's basically a coalition of conservatives who wanted to destroy the bill by putting this poison pill in it, and feminists who are like, let's go for it. And of course, it gets through. So the question before the court is, well, does this 1964 Act also extend to transgender and gay people? Justice Gorsuch was put on that court to basically do the opposite, to try to limit gay rights. He was thought to be a religious fundamentalist. But he's also a textualist. And the way he read that act, he said, look, the question is pretty simple. Does sex discrimination include discrimination against transgender people, against people who choose to be with members of the same sex? And he said, yeah, pretty clearly, that's the same idea. And it doesn't matter if they knew that. I just read the text for what it is. So that is actually a hopeful moment that this president, who was really trying to control the court, I guess, and that's not so much norm defying, that's probably pretty typical, was met with a pretty good example of the justice turning on him and doing, to me, what the law says rather than what the president wanted.
So, Cory, you spoke at Intelligent Speech last year when we had the physical conference in New York. You're going to be joining us this year on June 27th, which is going to be a virtual conference. What are you going to be talking about, sir, and why?
I'm going to talk about the presidency and the Constitution and the history, really, of how presidents have attacked the Constitution and the surprising way that we've recovered, not through courts, which really have almost never been there through the American people, but through a combination of citizen demands, citizen interpreters, pressuring presidents to do the right thing.
Fantastic. Cory Brettschneider, constitutional law scholar and professor at Brown's University. I've got that correct.
Brown University.
I've got all of your credentials out there. Thank you for coming on to Intelligent Speech, speaking live. It's great that we had a few people watching us and leaving comments. So we've been live on Facebook. And if you've missed the start of this, you can just, when we get to the end, hit play again. And you can also see this stream on YouTube. Don't forget, you can go on to intelligentspeechconference.com and purchase a ticket for the conference, which is happening on June the 27th. Tickets are only priced at $10 for 8 hours of intellectual entertainment. Thank you, Cory.
Thanks, Roifield.